What's up, guys? Todd Robinson here. I wanted to share another video with you about a decision tree that we created to determine whether or not your deal is going to be considered a joint venture or is it going to be a security for the purposes of complying with the SEC regulations. So here's a quick decision tree. We can jump right into it. So is it a security or not? And the Supreme Court defined basically a security as an investment contract back in 1947. So when you're taking down real estate deals and you're using passive money from investors, you need to decide whether it's going to be a security or not, and whether you need to comply with securities regulations. So the first question in the decision tree is how is it managed? How is the property managed? So if it's member managed, that typically leads one to believe that it is a joint venture, because the idea is that all of the members of the company are managing the property together. You may hire or designate a managing member, but in that instance, everyone is considered to have an active role. So if that's the case, then we are in what we like to call the joint venture role, not a security. Don't need to worry about SEC implications. Now, if it's a manager managed role and the company hires a separate manager, it's still a part of the GP group, but you have a non-member manager, which is how we like to structure them, but you have a non-member manager that is managing the deal, because what the impetus is that the non-member manager is managing the deal for the investors. The investors are the actual members of the company, and the non-member manager takes a management role and takes a fee for that management. But in that instance, you're going to decide that it's going to be a security. That's typically, leans towards a securities compliance requirement, because it's a manager managed role. Now, there's further decisions to make. You could have a manager who's also a member of the company, and it's just designated a manager managed company. And in that instance, it could be a joint venture if the member who's also a manager takes an active role along with other members. But generally speaking, if it's a manager managed entity, then it's typically going to have to comply with SEC regulations in a syndication context, or a context where we're purchasing real estate using passive investments. So once you get to that part of the decision tree, there's two types of exemptions under the SEC regulations. There are large public offerings, right? These are Reg A offerings. These are public registrations. So when you think about, Tesla going public or Uber going public, those are large public offerings that actually flow through the SEC first, right? The SEC actually investigates those offerings. They approve them. Investment banks are hired. That's how they create the shares. And it's a public process, right? So the SEC approves it first. Once that goes through the approval process, then the shares are offered to the wider public. That's a public offering. That's different than what we talk about in real estate syndication. What we talk about is Reg D offerings that are exempt from SEC public registration. Now, you still have to give notice to the SEC and file what's called a Form D with the SEC, but we are in that world. Okay, so what I've highlighted here is we are in the Regulation D exempt offering world. And so what the SEC has said is that, okay, there's public offerings and there's private offerings. Private offerings don't have to go through SEC scrutiny first, but you still have to give notice to the SEC when these exempt offerings occur. So now they're in the exempt offering world and we're doing a real estate syndication. We got to figure out, who can we talk to? There are typically two options when doing an exempt offering under Regulation D of the Securities Act of 1933. And this is where the rubber meets the road, really. So you have a 506B offering, you have a 506C offering, and these are just references to the specific regulation in the law. And so these offerings determine what exemption you want to travel under, determines who you can raise capital from. Very important distinction. A lot of people out there just talk about raising capital, but you need to first figure out, are you raising capital from accredited investors only or non-accredited investors? And so how are you going to figure that out? Well, you need to figure out first, is your capital coming from? Who is your typical investor? And whether they're accredited or not. I'll do another video on accreditation versus non-accreditation, but for these purposes, let's talk about 506B and 506C. 506B we like to call the friends and family exemption. Okay, this is the exemption that you'll travel under if you're going to raise capital from 35 unaccredited investors, right? You see that right here, max 35 sophisticated. Sophisticated, unaccredited, kind of the same thing. And you can have an unlimited amount of accredited investors, all right? But here's where the rubber meets the road. No advertising, no solicitation. You cannot go out and advertise this on Instagram, advertise it on Facebook, LinkedIn, do webinars where you have strangers that come and watch and then you want to go sell them investment opportunities. You can't do that in a 506B exempt offering. You need to have, and here it is right here, you need to have a pre-existing substantive relationship, okay, with the investor. Now, what that is, we can talk about that a little bit later in a separate video, but generally speaking, you need to know them, have some contact with them, and really need to have that relationship established before the offering is available for investment. Now, a 506C offering, but neither of these have any limits on what the amount that you can raise. But at a 506C, you have no unaccredited investors, okay, and then you can have an unlimited amount of accredited investors, but you're allowed to advertise. So this is where you can raise capital from strangers, right? You can go out and advertise this to the wider public, but the SEC drew a distinction and said if you're going to do that, you cannot take unaccredited investors because the SEC's main goal is to protect investors from unscrupulous, sponsors. So they said, look, we'll allow you to raise capital from strangers, but they all have to be accredited. All right. And accredited means net worth of $1 million or more, excluding your primary residence, or if you're single, a salary of $200,000 or more. If you're married, a salary of $300,000 or more. So this is the two exempt offering options when you're raising capital privately in a real estate syndication. Now, in a 506C, last thing, you don't need a pre-existing relationship because these typically are strangers. Now, you can have accredited investors that you know that are a part of your network, and they can invest in a 506C. But the real rub is if you want to advertise, you have to do a 506C offering. And as always, guys, make sure you subscribe. And if you have any questions about this, make sure to reach out.